future. But what I'm trying to say is, but even then, it will be certainly in the wisdom of the Parliament, the act has now been enacted.
No, you may
The act, I'm sorry.
You may not be able to undo something what has happened.
That's right. That's the
Then
first chapter.
For the future, whether this same kind of power should be exercised or not.
My only response is, would it be in the nature of an advisory jurisdiction by the court in future? You would do that.
The way it is said, not
I only suppose it wouldn't. Your lordships may not enter into an advisory jurisdiction.
Strictly speaking, it may not be advisory.
In a manner of speaking, it would be an advisory.
Though we may not unsettle something, but we can always lay down a law.
Yes.
No, providing lords are striking down a law. If a law is being struck down, you lay down a law. But if your lords are not going into striking down the notification, the question of laying down a law may not ordinarily arise. But I feel
Many
it
of
would be
the-
a very
Many of the leading judgments of this court are advisory in nature. Subsequent, for SR Boma is
for a number of reasons. For a number of reasons.
The event had.
Lord, your lordship's,
I only
your
think
lordship's,
that
your
Lordship
lordship's
treading on
power to give a declaratory order does not depend upon whether the matter can be, whether the relief prayed for can be granted immediately or you have to mold the relief. Your lordship's power under Article 32 and 226 and 142 is declaratory. You will declare the law. We need to know what the law is. Parliament needs to know what the law is. Government needs to know what the law is. When will this law be declared? If this case is not a suitable case to declare the law, the next demonetization also, in the future, perhaps the same learned Attorney General will come and say, this has been done. So when will you declare the law? The declaratory power of this honorable court does not depend upon what relief you can grant and what relief you cannot grant. Kindly look at the language of 142. For this court is binding.
The questions which are raised.
See, there are two aspects. But what they are trying to highlight, I think, the petitioners is the procedure or the manner in which it was done. That is what they are highlighting.
Even while the court may be called upon to answer this very important question, the court will certainly enter into other domains. It can't answer it in abstract. It has to go into this question, whether the law should have been enacted and which is the outer limit of section 26. All those issues necessarily arise, and we have to enter into a wide range of issues on economic policy.
Not on
I'm not saying the laws will not go into that.
Not on economic policy. The two aspects are different. Whether the government in its wisdom could take such an action is possibly beyond the pale of the court. But whether the manner in which it was done, the procedure which was adopted is a matter which could be considered, and that is where they're saying give a declaration on it.
Be able to satisfy the court, the manner in which the government had to do it had certain sufficient justification. But the court will then enter a justification process. Therefore, it's a very grey area in economic policy making, where the court probably, I think, will defer to the wisdom. And now we are, therefore, why do you want to enter into the procedural part of it? So the Parliament has gone into it.
To come to that conclusion, should we hear? Or
I quite see that. I don't say that we are averse to the court going to the question, but I only saying that court will necessarily enter into wide range of connected issues, which cannot then unentangle. Quite a number of issues are there.
Well, the laws travel far beyond what the learned Attorney General is saying. Your lordships have now said every action will be tested on the doctrine of proportionality. Even if it's economic policy, it can be tested on proportionality. Therefore, the laws travel far beyond, my lord, all these 20-year, 30-year-old theories. Therefore, even if economic policy, well, I'll pose a question. Suppose tomorrow a government decides 100% of all currency notes will be demonetized. And if they're demonetized, but will you not, lordships, not test it on the doctrine of proportionality? If suppose, well, the only currency notes that were available at that time in 2016 were, I think, 2 rupees was the lowest denomination. Suppose even 2 rupee note had been demonetized. Well, please remember, 86.4% represented 500 and 1,000 rupee notes. There were very few 2 rupee notes, 5 rupee notes, 10 rupee notes, 50 rupee notes, and 100 rupee notes. We think that they are the common currency in circulation. That is not so. C in C. currency in circulation, 86.4% was 500,000, and that was taken away. And tomorrow you say exercise power under 24 and 26, I will take away 99.9%. Then the court is powerless to test it. It may be sound economic policy or unsound economic policy, but your lordships can't test it on the doctrine of proportionality. Of course, your lordships can. Your lordships, I think one of your lordships delivered a judgment in proportionality, Justice Ramasubramaniam. There is a judgment of Justice Chandrachud on proportionality. We will place all those judgments. But to stop us at this saying it's all academic, it's not academic. Please hear us for at least an hour, then decide whether it's academic or not.
Kindly do that, while adopting the submission, respectfully adopting the submission of the legislator. But essentially, it's for your lordships to take a call, whether to hear it on merits or otherwise. We have filed our reply long back, and we have an answer to each and every question raised. But this is not the occasion today to respond to them on merits, and therefore we are not responding. But I must tell your lordships, so far, whatever are the decisions rendered by your lordships on your lordship's jurisdictional to interfere in the economic policy regime, your lordships have so far not examined it on the ground of proportionality. And the reason is very obvious. It is essentially for the executive based upon several factors, which some of which may not even come in public domain, to take certain policy decisions immediately in an emergent situation. One of them can be terror funding. So, my lord, these are the issues. The question is whether your lordship would like to go into it. If my learned friend wants it for an hour or so to decide whether the court should, my lord, go into it, Lord, your lordships may do so. But as the learned Attorney General, Lord, I am respectfully, Lord, adopting the submission that it may perhaps eventually be, Lord.
All right, we will hear Mr. Chidambaram or Diwan, whoever, on this question for the present, and let us see how things take shape. Whether we should decide or not.
Yes, Lord, may I suggest, Lord, on behalf of both of us, Lord, if your lordship would like to examine for an hour or so, my lord, whether to hear what are the prayers, etc. Then, my lord, we may also need some time. Sure. The lordship may have, my lord, immediately on whatever date, my lord, possible.
One of the concerns which I want to share about, while all these arguments
Anita is not here. All right.
Your Lordship.
Let the petitioners begin. Let us see how, after some time, how things take shape. And for you, we will grant you time. There is absolutely no problem. Let them make a beginning today. What do
We
you
have
say?
no difficulty about that. Certainly, your Lordships will have the last say on that.
What-
But I only want to share some concerns.
Huh?
Again, to not the cause of repetition.
Huh?
To introduce arguments such as proportionality and inviting the court to get into certain very important questions of economic policy
Huh?
will be a very high decibel invitation. So I think the court may have to be very slow in getting into the argument, particularly in the realm of, say, now it's no longer a mere domestic banking decision. How will the government deal with a banking policy at a global level? We have so many issues arising in even domestic intervention. So the court, therefore I say the court will be very slow in getting in, because the moment the court goes into any one of the issues, then a wide vista is opened up.
Mr. Attorney, to make up our mind, we must hear them.
Your Lordship, I have no difficulty about that. I
Even
only want to
to-
flag
even
this
to-
concern, that's all.
Even to understand what they are saying, we may, and for you, we will respond, we will grant you time, there is no problem. Or is it, are you saying that today, let us not begin, we will have it on some other day? Are you saying that?
That probably that would be desirable, so that we also take stock of all the arguments advanced today. We come back with a more structured way of addressing the court. Otherwise it becomes ad hoc.
No, but then,
Hearing.
if we hear them today,
Very well. Yeah.
you will know what is to be responded on the next date.
I have no difficulty about that. But I thought some structured way of taking the time of the court and addressing the court, we should probably organize our hearing process. We are not, I don't think we have done it.
But then today's date was fixed with everybody's consent.
Yes.
But of course, attorney was not
Attorney
there
was not
last hearing. We know
Yeah,
that also.
I am a privilege to address the court today on this very important.
Brother Ram. Yes, Mr. Attorney.
I thought let me formulate some threshold. Getting into all those questions the court has formulated earlier. I think some of them have really become academic. So a few threshold issues, the court can look into them and thereafter take a view whether you need to go further or not.
That is
That's why
why
I thought more.
You want to know what the threshold issues are, we have to hear them.
heard them.
By order dated
16 December
16th of
2016.
December 2016, 9 issues have already been formulated by a 3-judge bench of this court presided over by Chief Justice Thakur. I was there, Mr. Sibal was there. We gave draft issues, they have been formulated. If the learned Attorney General wishes to formulate more issues, we have no objection.
I want to reduce
These are issues have already been formulated. This is reported in 2017, 1 SCC 388. It's also in the paper book. 2017, 1 SCC 388.
Milord, may I make one submission, Milord? I appear for the Reserve Bank of India. Now, Milord, these issues, 9 issues, are all relating to, Milord, the notification. Subsequently, Milord, there have been legislation. Now, several petitions have come after these issues were raised. So, Milord, if my learned friends wish to address your Lordship on those, and some of them are in the list today, some are not. If they wish to, Milord, it would help, Milord, subject to what your Lordship speak, Milord, if they were to indicate what are the issues on which they wish to argue. Because, Milord, then your Lordship will have in front of you what is it that your Lordships are called upon to decide. If your lordship is starting today, my lord, no difficulty. If you're not, then, my lord, it may be a good idea, my lord, now that there is many more writ petitions than were there on the date of this order, for them to indicate which are the ones which they are addressing.
Or there might be some additional issues also.
There will definitely, because, my lord, the legislation and the ordinance and the act came subsequently.
They're not under challenge.
Because may I, with your permission, just read through the orders? Let us, if we go through the orders, all of this will become clear.
All right, let us see, let us make a
Very
big.
well.
Yes, let us make a beginning. Because if your lordship is just.
There are,
pleased to
where is
take up.
that? Where is that?
Yes, so I have set them in a compilation. We've requested the court master
Where
to
is-
keep them out. Just let us see our orders of our court. It's a compilation of documents in IA 26757 of 2018. Your lordships have that. I'm only focusing on the orders. Let us just see how it develops. Yeah.
But we are sorry, we can't provide chairs to all of you.
No, but we are just now, I just want to take your lordships through these orders. So let's see how it develops. To page 1.
Yes.
Correct. Now, this, please note, this is the order which Justice, which Mr. Chidambaram was referring to, 16th December 2016, bench presided over by Chief Justice Thakur, page 1. Your lordships have it?
My lord, if my learned friends can give us a copy of the.
Yes, we've give you a copy now. So give it to you. Yes. So I'll just read it.
Yes.
So, Manoj, writ petitions, your lordships will see that a whole bunch of writ petitions are admitted. Issue notice on the writ petitions, specially petitions and other applications. We have heard the learned counsel for the parties at some length. In our opinion, the following important questions fall for our consideration in this batch of petitions. Now, these are the 9 questions formulated. Please see whether the notification dated 8 November 2016 is ultra vires 26(2). Section 717 so-and-so of the RBI Act. This is what Mr. Chidambaram was projecting a short while ago. Does the notification contravene the provisions of Article 300A? Assuming that the notification has been validly issued under the RBI Act 1934, whether it is ultra vires 14 and 19, whether the limit on withdrawal of cash from funds deposited in banks has no basis in law and violates 14, 19 and 21, whether the implementation of the impugned notification suffers from procedural and or substantive unreasonableness and therefore violates Articles 14 and 19, and if so, to what effect? In the event that Section 26(2) is held to permit demonetization, does it suffer from excessive delegation of legislative power, thereby rendering it ultra vires? What is the scope and effect of matters relating to fiscal and economic policy of the government? This is the issue which was raised by the Attorney General and the Solicitor General. Whether the petition by a political party on the issues raised is maintainable under 32, and whether district and cooperative banks have been discriminated against by excluding them from accepting deposits and exchanging demonetized notes. Keeping in view the general public importance and the far-reaching implications which the answers to the questions may have, we consider it proper to direct the matters to be placed before a larger bench of 5 judges for an authoritative pronouncement. The registry shall accordingly place the papers before the Honorable Chief Justice for constituting an bench. Then, Manoj, there is a further narrative with your permission. I'm just skipping a few pages and going directly to page 6. Please go to page 6. Yes. The other broad point, your lordships have that? The other broad point on page 6. The other broad point was about extending the time limit for exemption for use of demonetized currency notes of rupees 500 and 1,000 at specified counters as per the relevant notifications issued in the behalf of the Reserve Bank of India. It was contended that the exemption period provided in the concerned notification is expiring. Hence, it will not be possible to deposit the demonetized notes at specified counters thereafter, even in case of emergency situations like hospitalization, travel,